if I'm a business and I think I have trade secrets, and you've just delineated several ways in which it can or may not be a trade secret, how do I go about making sure that those things are protected? And you said an employee handbook, stamp it trade secret, treat it as it is secret, and let people know that it's secret?
Absolutely. And you also want to make sure that you limit access to those types of secrets to those who really have a need to know. You might also keep some records. You know, I told XYZ that this was our algorithm for determining who was a qualified client. Those types of things can also be indicia that it's not only a trade secret, but that you're taking reasonable steps to protect it.
One of the things that you've said many, many times in the past, Sam, is that to get, not only to get it in writing, but also the minutes of your corporate meetings ought to be able to perhaps indicate what is or what isn't a trade secret, or at least an agreement with the board so that they're aware?
I think there needs to be a distinction between describing the trade secret and listing the trade secret.
Yes.
If you've got the secret formula, you may want to put in the minutes that the secret formula for birthday cake is something that we consider a trade secret, and we want to make sure that no one who doesn't need access to it doesn't get access to it. On the other hand, you don't put in the minutes, and the formula
is
you use this many eggs and the flour. And,
no.
But what you could do is allude to what you consider to be a trade secret.
We're talking with Sam Kreamer, ladies and gentlemen, of the Kreamer Law Firm, about non-competes and trade secrets. Do many companies have trade secrets?
I think more companies have trade secrets than they realize. But again, enforcing these misappropriations of trade secrets can be very expensive. Now, the remedies for a misappropriation are also important. A company can get damages for the misappropriation, and those damages might be measured by the benefit to the company or individual that actually utilizes the trade secret. More commonly, companies try to get injunctions, and what they try to do is prohibit the individual or the company from utilizing their trade secret against them. Now, one of the nice parts is arguably you can get attorney's fees in these types of cases. However, there's two really big issues. Number one, how much are the attorney fees going to be? And number two, how much can they actually pay? Now, how much are they going to be? They're going to be whatever the attorney charges, but the court may look at this, and the court may try to decide how much is going to be payable by the company and how much is going to be payable by the misappropriator. But the real question becomes, how does the company pay it? It's my finding, and it's just empirical and has no basis in research, that by the time companies are trying to steal each other's trade secrets, either they're very large, DuPont and Monsanto, or they're very small, Mustard's trying to steal the pizza recipe. If they're small, there's no way to pay. If they're large, these fees could be extraordinary.
What's the best way to guard against making a common mistake, not knowing that you have trade secrets for one thing? Is that doing an internal audit and saying, okay, it's just sitting back thinking, okay, what do we know that we don't want other people to know?
I think that's the ultimate test.
Yeah.
Is what is it that if someone else got their hands on could put you out of business? That could be used as a test for whether or not something is a trade secret. Then the question is, what are you going to do about keeping it secret? And what are you going to do so that the law recognizes the efforts that you have made? Because if you don't treat it like a secret, neither will the law.
Yeah. Interesting stuff. We've learned so much. I mean, this is talking about issues that I would suspect face almost every company. Maybe not so much in the trade secret area, although I guess, if you're bebops out there and you've got a way of making those burgers, you don't want everybody necessarily to know about exactly how you season things.
Recipes are an excellent example of what could be a trade secret. Now, conversely, these non-compete agreements are really a way to prevent your biggest asset, which is your employees, who go home every night with your biggest issue, which is your trade secrets, from becoming your biggest competitor. And if you need or want to make sure that somebody can't compete with you for a specific reasonable period of time within a specific reasonable geography, the best thing to do is to create an employment agreement which would contain both a non-disclosure, thereby eliminating the misappropriation of trade secrets issue, as well as a non-compete.